Hello and welcome to Schiff Hardin's presentation, Navigating the Accommodation and Leave Landscape. We are pleased that you have decided to join us for this important topic. A copy of the presentation can be found in the Handouts section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. If time allows, our speakers will answer the questions at the conclusion of today's presentation. If we do happen to run out of time, the speakers will follow up after the presentation to answer your questions. I would now like to introduce today's speakers, Nora Kirsten Walsh and K.M. Zuhari. Welcome. The floor is yours.
Wonderful. Thank you to everyone for joining us today. My name is Nora Kirsten Walsh, and I'm counsel here in at Schiff Hardin's Labor and Employment Practice Group in Chicago.
And I'm Katie Marie Zuhari. I'm one of Nora's colleagues based out of the Ann Arbor office. And like some of the laws that we'll be discussing today, I too go by my initials, KM. And thank you for joining us.
Thanks, KM. Our goals today are threefold. First, so that we are all on the same page, we'll be presenting a brief overview of the FMLA, the ADA, and state workers' compensation laws. Next, we're going to be discussing ways that you might analyze employee injuries and illnesses and your obligations under them so that you can remain compliant. Third, hopefully, as mentioned, we're hoping to take some questions from all of you.
And I guess another goal of this presentation, when we're done, we hope that FMLA may stand for feeling mighty less anxious, because these laws typically intersect in a stressful moment. An employee is injured on the job, there's confusion around a leave of absence, or there's difficulty with an employee's return to work. And as Nora and I discuss these topics, we hope that a brief refresher on the basics will be helpful, in addition to a framework when it comes to employee notice, documentation, return to work, and the ways that multiple laws impact those various decision points. And before we get going, I guess one quick footnote, or whatever the PowerPoint or webinar equivalent of a footnote is, we will not be covering any specific state or local leave law or accommodation law or workers' compensation law in this presentation. And you should just note what your own state or local governments may have in terms of family and medical leave laws or disability laws, as they may provide even more expansive rights than the laws that we'll cover today. And a leave may count and need to be coded, not just under the FMLA, but also a state law. And a note, this landscape is ever shifting. Just Monday, Georgia, I know we've got some folks joining us today from Georgia, passed a new law allowing employees to use their sick time to take care of their own family members. So this is something where it really helps to know your state and local laws, but unfortunately, we're not doing a complete survey of the entire landscape today.
Okay, so we're going to start off with an example that I imagine some of you have addressed, or at least something similar with your own workforces. An employee suffers a severe lower back injury at work, and he's incapacitated for 4 weeks and requires continuing treatment and rehabilitation therapy afterwards for several months. Also, for that period, he has a hard time walking, standing, and lifting, and is limited in those tasks. Immediately, of course, we treat this and think of this as a workers' compensation event under our own state's workers' comp laws. But if the employee is eligible for leave under the FMLA and the on-the-job injury is a, quote, serious health condition, which we'll be talking about shortly, it's important to know that workers' compensation leave can also be treated as FMLA leave. On top of that, a request for leave, whether under the FMLA or leave under the workers' comp laws, can also be deemed a request for accommodation under the ADA. When we think about these overlapping laws, we want to be sure that we are complying with our obligations, but also taking advantage of any assistance that we have as employers with respect to certain requirements of the employee under these laws. For instance, if an employee is on a workers' compensation leave and receiving workers' comp benefits, an employer may wish to also have this leave count against the employee's FMLA entitlement, if in fact they are eligible and this qualifies as a serious health condition. The employee must be given notice that the leave is being designated as FMLA leave and is running concurrently with the workers' compensation absence, but this is a very good example of how this can all work. If the employee's FMLA leave is exhausted, then the employee would have to look to protections of the ADA or other statutes or protections for any continued leave or accommodations. So the point is that I think you all know that there are overlapping leave rights and other rights under these laws that we have to consider when we become aware of an injury or illness, whether or not it's even if it's not a work-related illness, there can in fact be overlapping concerns with the ADA and the FMLA leave.
So what are the questions that we typically ask, and how do we frame the analysis when something happens? First, it's what is this injury or illness, and what laws then apply? So with this back injury, we have a different set of questions under each law that we need to ask. If the employee was injured at work, there are emergency conditions that allow you to know, yes, we're on notice of something happening in our facility. But what if the employee goes home and then, the injury really develops there, or the illness develops there? How do you get notice of this? As a practical matter, how long will the employee be off work? How long will your business be impacted? What medical questions can you ask of the employee or the employee's medical provider? And then really this is where we speak with our clients all the time. What's going to happen, or when is the employee going to return to his or her job? Is it the same position? What does an equivalent position mean? So through these questions that come up as we analyze an employee's injury or illness, we'll take a look at these questions as our framework for looking at the FMLA, the ADA, and workers' compensation laws.
Okay, we don't want to make this a full-day webinar on any of these statutes, nor do we have time. And you are probably familiar with the basic components of these statutes, but it's always worth a quick refresher. Let's quickly think about the ADA. Of course, the ADA has key components. The first are anti-discrimination provisions, where employers who are covered under the law cannot discriminate against qualified applicants and employees with a disability in any terms and conditions or employment. The more prevalent for our discussion today, the ADA requires employers to make reasonable accommodations that will allow employees to perform their essential job functions. And then, of course, this law, as others, prohibits retaliation against individuals who've either opposed or challenged what they believe to be unlawful activity under the ADA, or an employer who interferes with the employee's exercise of rights, such as the employee's request for an accommodation. Again, like the leave laws and the sick leave laws that KM just mentioned, there are, of course, state law corollaries to the ADA that you have to be cognizant of when you're dealing with an ADA-related issue. Oftentimes, in Illinois, Illinois certainly has one, but other states will have a corollary that has similar provisions. Sometimes they differ. And like as we just mentioned with respect to leave laws, generally you're going to have to provide the benefit or the protection that is most protective of employee rights. So you'll have to analyze obligations under the state law or local law, if it exists, and the ADA when you're assessing these kinds of situations. Could you go back a second? One point, we are all familiar with the term accommodation, and we don't need to spend a lot of time on what that is. It's basically a change in the work environment or in a way that things are done that will enable an employee with a disability to enjoy equal employment opportunities as non-disabled employees. These, of course, can include things like modifications to facilities or schedules, equipment, adding equipment, changing our policies, restructuring a job, etc. But importantly for our discussion today, as you probably all know, the EEOC has made clear that leave can be a form of reasonable accommodation if it does not pose an undue hardship. Importantly, it has made most clear in a guidance that the EEOC recently prepared and submitted in 2016, the EEOC also clarifies that any time an employee makes a request for leave under the FMLA, it should also be deemed, it could also be deemed a request for leave or accommodation under the ADA, and we'll talk a little bit about that today. But again, it goes to the overlapping nature of both sometimes something that can be an illness or an injury under one statute can be another, fall under another, but also the rights and protection under one have some similarities with the other statutes as well. Okay, again, the ADA protects qualified individuals with a disability. You're all familiar with this term. A disability is a physical or mental impairment that substantially limits one or more major life activities, or having a record of such impairment, or being regarded as having such an impairment. And of course, it protects only folks who are not only disabled, but who are qualified, which basically means that they're qualified to perform the essential functions of their position or the position at issue. Importantly, in 2008, there were some amendments to the ADA where Congress and the DOL made clear their view that the definition of a disability should be construed broadly so that we won't have these legions of cases necessarily where whether or not someone is disabled is being litigated to the nth degree. It doesn't mean that the employee doesn't still have to establish or prove that they are disabled. That element of a prima facie case or the element of their claim that they're disabled still exists. However, the statute has been, Congress has made, and particularly the DOL, the EEOC has made clear that they don't want this to be the feature. It shouldn't be that hard to determine whether or not someone is disabled, and we should be construing it broadly so that more folks can be covered essentially. ADA applies to employers with 15 or more employees during the current or preceding calendar year, but this is a place where you have to be mindful of your state law requirements. If you're a small employer, you may not be covered under the ADA, but you still may have accommodation and or non-discrimination obligations under your equivalent state law. So you have to be mindful of those things.
And now a high-level look at the FMLA. The FMLA provides employees who are eligible with up to 12 weeks of unpaid leave for a couple of specific reasons. The one we'll focus on for today's purpose is an employee's own serious health condition. And the leave can be taken in a couple different ways, all in one go. They can take leave around a surgery or something like that that'll be a couple weeks, or intermittent leave, which can be for treatment or things like migraines, mental health issues. Intermittent leave often arises and often raises a lot of questions. One thing to really note is that an employer must restore employees to the same or an equivalent position. There is an exception there for key employees, which we won't go into in great detail, but that's something to visit, whether or not an employee is considered a key employee under the regulations. That can change the right to reinstatement. One key difference between the FMLA and the ADA comes with the question of health insurance benefits. So the FMLA does require that employers maintain health coverage during leave, and that's the same conditions as if the employee was continuously employed. In some instances, an employee will need to pick up payment for a premium while on FMLA leave. But it's important to note that the ADA does not require the maintenance of health insurance unless other employees receive it under the same circumstances. So when you've got a leave that's covered by both, it's important to note what the FMLA does require, and that's the maintenance of health coverage. And as Nora talked about some of the issues with retaliation against an employee under the ADA, the FMLA, too, says we're not allowed to retaliate or interfere with the exercise of FMLA rights. So now comes the question of the serious health condition. If we can move forward. What's a serious health condition? The short answer is it's a very long definition. But the short answer of that long definition is a serious health condition is an illness, an injury, an impairment, or a physical or mental condition that involves either inpatient care or continuing treatment. And as you would imagine, both of those are also defined terms. It's key to note that incapacity can also include pregnancy and prenatal medical care. So how do these overlap? Some serious health conditions are also ADA disabilities. For example, cancer, or if an employee suffers a serious stroke. but other examples might not be so clear. And in fact, the FMLA regulations say ADA disability and FMLA serious health condition are different concepts. You have to analyze them separately. So there was a recent Seventh Circuit decision where the Court of Appeals affirmed a decision in favor of a lower court, a Chicago-based hotel chain. And there the employee filed a claim saying that he was disabled under the ADA and that his disability was sensitivity to electromagnetic voltage. And this could have been one of those instances, although the employee just brought the claim under the ADA, where workers' comp or FMLA were implicated because he was saying, look, on the job as a front desk clerk at this hotel, I'm being exposed to these high levels of electromagnetic voltage. And this is where these definitions become really important. The district court and the Court of Appeals said, look, front desk clerk, we have no evidence that you suffered from an impairment that substantially limited a major life activity. And so you are not disabled under the ADA with your sensitivity to electromagnetic voltage. And that's also one where if, there was no ongoing treatment or no inpatient care related, he would have had a difficult case. But there is an area between sensitivity to electromagnetic voltage and say, a serious stroke. So what about, say, a broken leg or a hernia? Nora, do you have thoughts on those and whether or not we're going to look at something that is both a disability under the ADA and a serious health condition under the FMLA when it comes to a broken leg?
Well, believe it or not, I have seen a decision out of one of our federal circuit courts of appeals that actually made a determination that an employee who had fractured a left leg, had a torn tendon, fractured an ankle, and had, severe injuries to his legs and tendons and ankles, and then couldn't walk for a number of weeks, and then couldn't walk normally, and was limited his ability to walk normally for 7 months. That court, actually looking at EOC regulations, made a determination that even though this was a temporary condition, it could be an actual disability if the condition is sufficiently severe. So we are not going to say that every time someone has a broken finger they're disabled, but the point is that sometimes something that you as an employer may deem to be a temporary non-disabling condition may in fact qualify as a disability under the ADA. As with everything under the ADA, you have to look at the facts and the circumstances of each case.
Well, and that's true of the FMLA too. I guess it's a case-by-case or, in this case, a broken leg by broken leg analysis that has to occur.
That's right.
And then we'll move on to who's covered just briefly, because we know that most of you who are joining us here today are an employer with 50 or more employees within a 75-mile radius for at least 20 weeks during the current or preceding calendar year, and that geographic test is the same for employees who work at those facilities. And the key here is that they have logged 1,250 hours in the 12 months preceding the date for leave. So it's making sure that they have logged the appropriate number of hours to be eligible, and we'll get more into that later when we talk about employer notice requirements. On to workers' comp.
Okay, well, as we mentioned, we aren't going to be able to delve into each state's workers' comp laws, and we imagine that a lot of you are familiar with the components of your own state's workers' comp laws. Generally, of course, state workers' compensation is a no-fault system that's going to require employers to carry insurance, to provide wage replacement, medical expense, and pay for medical expenses and other benefits for employees who are injured on the job or who suffer an occupational illness. Of course, many states, including Illinois and others, prohibit employers from retaliating or taking an adverse action against an employee who exercises his or her rights under the law. And we've certainly seen and looked at and handled cases where someone has claimed that their termination was in retaliation for having filed a workers' comp charge. So you have to, workers' comp claim rather. So you have to be mindful of these provisions as you're trying to work through a workers' compensation, a long-term workers' compensation injury. You also have to be very mindful of the contours and the intricacies of your own state's laws. with respect to coverage, with respect to obligations, and some of the other things that we'll be talking about today, and your rights and the employee's rights. So you have to be aware of the intricacies of your state's laws. Generally, most employees who have been hired and are on the payroll are going to be covered under the workers' compensation statutes. There are some states that exclude minimal categories of employees, but that's typically not an issue. Again, we can't make a blanket statement about every employer in every state, and because employer coverage will vary state to state, but generally, most if not all employers are going to be covered under a workers' compensation law, as long as they have one or more employees. But some states have exceptions for small employers whose employees don't meet certain thresholds.
So this slide provides information on the administering authorities for the various laws. In addition to the oversight from these administrative agencies, the Department of Labor's Wage and Hour Division, the EEOC, and then state workers' compensation commissions, we also see individuals bringing claims under these laws. And what's interesting is the increase in recent years in claims under the ADA and the FMLA in particular. For example, in fiscal year 2015, the largest number of EEOC-initiated lawsuits involved ADA claims. And there was widely reported from 2012 to 2014 an increase from 291 FMLA lawsuits brought to over 1,100. And so what sorts of actions will bring about an FMLA lawsuit when we're looking at this kind of number? The most often filed are those that arise because of a termination decision, and then also FMLA discrimination, a refusal to grant leave, sometimes a refusal to restore to an equivalent position or to maintain health benefits. So as we go through some of the requirements on employers, it's, I think, good to visit the ways that employees tend to challenge some of these decisions.
Okay. Quickly, we'll just address that there are some notice requirements that obligate the employer to provide notice of rights to their employees. Under the ADA, that really shows up in the form of an EEOC poster that addresses numerous laws that the EEOC enforces. The ADA also requires certain notice requirements for employer wellness programs. That topic, we're not going to be addressing wellness programs in today's topic, but that is another place within the ADA where notice requirements exist. That's different
and right
from
next,
FMLA. Sorry, Cam.
Right next to the EEOC poster should be your general notice poster. The DOL requires a poster in a physical location or an electronic location if you have an employee portal where all employees have access, and also distributing a copy to new hires. The eligibility notice is one I referred to, I think, a couple slides back. This notice informs an employee that he or she is eligible for FMLA leave. So, for example, if an employee hasn't worked a certain number of hours in the preceding 12-month period, then this notice is how we let them know, I'm sorry, you're not eligible for FMLA leave. And if an employee isn't eligible, they could be potentially ineligible for more than one reason, but this notice only needs to provide them with one reason why they won't be able to take the FMLA leave that they sought. And this eligibility notice often is presented as with the DOL's model form with a rights and responsibilities notice. And this is really key. It's got to be in writing, and it needs to include a lot of information about what the company will do and what the employee will do while FMLA leave is ongoing. So this is where an employee would be notified if they were a key employee and potential restoration consequences of that. This is where an employee would learn about their right to job restoration, maintenance of health benefits, as we discussed earlier, whether they'll be required to make any premium payments, and critically, if there are any consequences to an employee not meeting their responsibilities while on FMLA leave. And then finally, within receiving enough information to say, yes, this is a serious health condition, after going through some of the questions we discussed earlier, once that's determined, then the designation notice saying this is the number of days that will be applied towards your FMLA leave if known. And also, the designation notice is key for those who will require a fitness for duty certification. This is where employees are notified that before you come back, you've got to let the company know that you are ready to come back to work with the fitness for duty certification from a provider. And I think we'll talk a little bit about that before we're done this afternoon.
The designation notice that KM just mentioned is key because, of course, it's important that the employee be aware that their time is being counted against their allotted FMLA time in the year. But also, again, if you are if an employee is on a workers' comp leave, and this could also be, or you would like to treat it also as FMLA leave, it's going to be important that the employee understand that. So these notices under the FMLA serve a very important purpose. Okay. Just like the employer has some notice obligations, the employee does as well. Generally, with respect to the ADA, generally the employee with a disability, who's of course going to have the most knowledge about their need for reasonable accommodation and what that might be, has to inform the employer that an accommodation is needed. Now, they don't have to use magic words. They don't have to say accommodation. They don't have to say disability. An employer cannot bury its head in the sand if they're aware that an employee may have a disabling condition that's impacting their ability to perform the job. But generally, it's going to be incumbent upon the employee to make it known that they need an accommodation to perform their job. There is a difference, by the way, in this requirement with respect to federal contractors. I believe that the regulations, applying to federal contractors require a more affirmative obligation if, in fact, the employer is aware that someone has a disability and may need an accommodation. There's a bit more of an affirmative requirement for the employer to approach that employee in confidence and see if there's something that they may need to assist them. But in any event, once an employee requests accommodation, particularly here because we're talking about leave for some medical condition, even if it's couched as an FMLA request, just be mindful that it could also be a request for a reasonable accommodation under the ADA, and therefore if the employee is not, even if the employee is not eligible under the FMLA or has exhausted their leave under the FMLA, they may still be entitled to leave or some other accommodation under the ADA or under other programs you may have. Once this is a request for accommodation or leave as an accommodation is made, then you have to promptly engage in the interactive process. This is a term that you all know, and it's a process that is designed to help the employer obtain relevant information and interact with and engage with the employee to help determine the feasibility of a particular accommodation that's requested so that such doesn't cause an undue hardship, and whether there are other accommodations that may work. So it's an important process. It's been announced by the EEOC. It is certainly part of the ADA framework after a request for accommodation is made.
And Nora's right, no magic words there, and also no magic words for an employee's notice requirements under the FMLA. The request need not reference the FMLA or, for that matter, a state or local leave law. Notice from an employee can either be in writing or it can be verbal. And if it's foreseeable, the employee's notice has to indicate how much leave is needed and when, and 30 days notice is what's required. And it's also important to note that an employer can enforce its normal call-in procedures during FMLA leave, especially for intermittent leave on a notice requirement. So the other thing to think about is what's unforeseeable leave and what does it mean to be as soon as possible. So the Wage and Hour Division's employer guidance on this actually uses an example that's close to my heart or probably more apt to my lungs. So thinking about an asthmatic incident, there's two scenarios. One is there's an asthma attack that requires immediate treatment at the emergency room, and the other is an asthma attack where inhaler treatments are administered at home. So for the former instance where an emergency room visit is needed and needed immediately, this is a situation that's not foreseeable, it's an unforeseeable, and the employee should provide notice as soon as practicable. Later, if it's the latter incident, rather, where there's an asthma attack with an inhaler treatment at home, that's something where typically there's going to be some time to inform an employer that there is a serious health condition at issue, that there's going to need to be follow-up treatment by a provider over the next 30 days, or some type of inpatient care if there's a hospital visit the next day to deal with the asthmatic incident. So I think that example is one where there's not a typical, big issue emergency, but one where there is something that's rather time sensitive to help draw the distinction between what's a foreseeable and unforeseeable incident that leads to a request for FMLA leave.
Okay, under the workers' compensation laws, again, I'm a total broken record on this, but we're going to be looking to your state law and also your policy as respect to what kinds of notice must be provided if the employee suffers a workplace injury, and they need to, typically there will be notification procedures outlined. You want to know as soon as possible so that treatment, of course, can be obtained if needed. So that's just something to be mindful of as you go through this process, and if someone is in fact injured on the job. And you all, I'm sure, are aware of your own procedures with respect to workplace injuries. Okay, medical inquiries. We're getting into the nub of some of the issues that you are all dealing with all the time or calling us about. Under the ADA, what are you allowed to ask for? What can you get? For current employees, you can make a disability-related question. You can have an inquiry. You can ask for doctor notifications, or even require a medical examination where it's, quote, job-related and consistent with business necessity. For these purposes today, if someone makes a request for accommodation and that the need is not known or obvious, or the disability is not known or obvious, and you need to know more in order to engage in the interactive process, that's a situation where you can request medical documentation or other information. Other situations, if you have a reasonable belief that an employee can't perform their job functions because of a disability, or you believe they pose a direct threat, there are limited situations that an employer can actually make what's called a disability-related inquiry. But the scenario of an accommodation request is one of them if it's necessary. Quickly, I say this applies to current employees because the law and the regulations are different with respect to what you're allowed to ask and do for applicants, both pre-offer and post-offer. We won't get into that now, but just bear in mind this standard of job-related and consistent with business necessity applies to current employees only. So that's what's allowed under the ADA. Okay, and what about the FMLA?
Well, with the back injury that we discussed at the top of the webinar, so say that the employee has a back injury, they were hurt on the job, the eligibility and rights and responsibilities notice portion of the back and forth, you give the employee 5 business days after learning of the back injury, and say, we're going to be needing a medical certification from you. So the employer may require a certification, and there are a lot of different components to this. The DOL does provide a model certification, and what's key there is you can create your own leave management friendly certification so long as it does not exceed the information that's in that model certification. And for brand reasons or leave management tracking reasons, that may be the best course. When it comes to the medical certification, an employee has 15 calendar days to provide a response. The employee is not required to give over any medical records. It's just the certification, and there is a significant amount of back and forth that can raise questions because employers are entitled to a sufficient and complete certification. So when there are questions about insufficiency or incompleteness of a certification, that can start a back and forth with the employee and then eventually the provider. So the question is, you get a certification back, it's incomplete, or an answer provided by the medical professional with the medical facts supporting the need for FMLA leave, or a question about whether the employee will be unable to work, in fact, or the duration of leave. These are the questions that sometimes are not answered in the initial go-around. And so after an employer gives an employee the opportunity to get the complete certification, then the employer can reach out to a healthcare provider, but only for purposes of authenticating a certification or clarifying it. And as we talk about the overlap and interplay between laws, there's also a note here that, HIPAA privacy rules do govern here, and there may be some HIPAA implications. And HIPAA requires a written authorization by the employee in order to release information for clarification purposes. So I think we started with a triangle. Maybe between state and local leave laws we're at a square, and I don't know what kind of shape, if we're at an octagon or hexagon at this point. But there are other laws that are implicated along the way in this leave and disability landscape to just think about, and this is one of them. And then, Nora, I think we talked, too, about second and third opinions. And so once that complete and sufficient certification is received for FMLA leave, if you have a reason to doubt it, the employer may receive a second opinion at the employer's expense. And then if the first and second certifications, we've got different conclusions about what's going on here, then a third healthcare provider approved by both the company and the employee can weigh in. But that opinion, if a third certification, if we go to the tiebreaker, then that one is final.
Thanks, Cam. And two follow-up points on that. Even if we're not in a HIPAA situation, meaning that if you're not a HIPAA-governed employer, and now you're the one who has the information in your hands that you've gotten from an employee who has given you this, or you've gotten it from a doctor with the employee's authorization. Once you have them, you also have to maintain the confidentiality of these medical records. They have to be kept confidential. They should not be in a personnel file. They should be maintained separately and of course, limited. Only those very specific individuals who need to have that information. But as a follow-up also to Cam's point about how the FMLA addresses, clarification and then second and third opinions, the ADA and its regulations don't have a clear-cut rule on what you do if a request or information from a doctor is unclear. And I know just from my experience in practicing law, that is something that you all deal with all the time. You get something back and you're saying, I don't get how this applies. What am I supposed to do with this information? Even though the regs and rules under the ADA don't address it as clearly or really at all, EEOC has put out some guidance that indicates that an employer who gets insufficient documentation to support a need for accommodation, if it truly is insufficient, by the way, that you can, again, sort of continue with the interactive process. So you can, go back to the employee, ask for clarification. You can ask for the employee's consent to interact with the doctor, or you can, we've helped clients put together sort of questionnaires, sort of follow-up questionnaires, where we need more information to determine whether an accommodation is reasonable or needed. If all of that doesn't work, then I think the EEOC would say that you could probably allow the employee to go to a healthcare professional of your choice, of course, by paying, and you would have to pay for that. But hopefully you can get enough clarification through the employee's doctor before it comes to that. Oh, and again, under workers' compensation laws, again, I'm speaking in very broad terms, but, in addition to the medical treatment that an employee may be getting because of the injury and the care that they receive, it gets to the point where an employer can, usually, again, this is state law dependent, require that the employee submit to an independent medical examination so that the employer can get a handle on causation and the extent of liability. Again, you'll want to be sure that your carrier is complying with the requirements of your state's law. Okay, light duty. What about light duty? The ADA, under the ADA, an employer does not have to create a job, whether a light duty job or other job, as a reasonable accommodation. So while you may offer light duty, you don't have to. That's not a reasonable accommodation. That said, there's an EEOC guidance that states that if you have a vacant light duty position, that exists, and that that employers kind of skipping around here, oftentimes employers do maintain or have light duty positions for workers' comp on the job injuries. And that's okay. You can distinguish between workers' comp and ADA on the job and off the job injuries. However, if you have like a bevy of just vacant jobs that you keep available, and those are available, and a person with an off-the-job injury or disability may need that, that might be a reasonable accommodation to assign someone to a light duty job, again, that is vacant, it exists, if there's no other accommodation. Again, this is very fact specific. It will depend on how your own processes and procedures with respect to light duty overall. The goals of workers' comp, of course, would be to have light duty to get employees back to work earlier, but you just have to be mindful. I don't know how many employers have just vacant, unused positions available. I don't know if that exists, but if it does, EEOC's view would be that may be something under the circumstances that should be given to an employee with a disability, even if it's an off-the-job, not related to the work.
Well, and I think, Nora, we can revisit our first scenario. So let's say at the outset that the FMLA says that employers can't require anyone eligible for FMLA leave to perform light duty instead of leave. But when we think about the employee who hurt her back on the job, let's say she's out in absence for workers' compensation. So that back injury that she had on the job also qualifies as a serious health condition. We've gone through the definition, and it qualifies as a serious health condition under the FMLA. So you have workers' compensation and FMLA leave are running concurrently, and all the proper FMLA notices we've discussed have been provided. So at some point, the employee, she goes to see her doctor, and he's providing the care for workers' compensation claim and certifies that actually the employee's back condition is improved, and it's time for the employee to return to work in a light-duty position. So as the employer, you say, okay, here's the position, would you like to come back? Under the FMLA, the employee, she'll have the right to accept, but is not required to accept the position. So if she's still eligible for FMLA leave, it hasn't been exhausted, she may continue to stay out on FMLA leave. So say that that's just what she does. She rejects the light-duty position. Then this is an inflection point where, okay, the employee may not continue to qualify for workers' compensation benefits, but the employee does continue on unpaid FMLA leave up until such point where the 12 weeks are exhausted. And so then at that point we have another question about if the employee's back injury is a disability under the ADA, and if there may be rights there under upon exhaustion, and whether or not light duty is considered again. So this is one instance, and the regulations really try and provide an example like this, where there are different inflection points where an employee may qualify under various laws, but there are decisions to be made. And one key one is whether light duty is the route to go down, or whether FMLA leave is going to be continued. And again, I'll just reemphasize, an employee is permitted but not required to accept a light duty position in that instance.
Okay, so how long can an employee take off? Under the ADA, because this is fact-specific, there isn't a mandated leave period, and leave, by the way, may not be required in all circumstances if there's another accommodation that is effective and that can allow the employee to perform the essential functions of their job. But to the extent an ADA qualifying individual is on leave, this is how long the leave will last will depend on the situations with that particular employee, their injury, and whether or not an extended leave poses an undue hardship for the employer.
And under the FMLA, it's 12 weeks in a 12-month period. With the notice requirements, one of them is to inform employees about what your 12-month period is. If it's looking back, looking forward, a rolling period based on leave taken. And as we continue to track leave, usually on an intermittent basis, the 12 weeks can take a little longer to accrue, or it's more difficult to track. So the notices are a good way to keep track of when the 12 weeks are exhausted, and then an updated designation notice would be provided to the employee saying at this time you've exhausted your FMLA leave.
Likewise, again, know your state's law. Oftentimes there isn't going to be a mandate for leave under workers' comp, although it often, or certainly a mandated time period, although that often occurs when an employee has a significant work-related injury. But generally under the state law, employees who take leave will be entitled to some type of wage replacement benefit under their state's law. Again, this is something you'll have to work with your carrier and any attorneys that you may use with respect to workers' compensation claims.
And Nora, there was a case here in the Sixth Circuit recently where it was a very sad situation where an employee who was really a valuable contributor was diagnosed with thyroid cancer. He was an operations manager, so was fairly senior. And he had surgery for the cancer treatment, but he could not resume work full time. There was a really significant back and forth, and unfortunately, he did not improve. And so Human Resources, he contacted them and said, this is a disability that's going to require an indefinite leave of absence, and his employer discharged him. And the employee went around and sued for a failure to accommodate and under the ADA. And there, the Sixth Circuit noted that the employer clearly had the right to terminate, and they used those words, clearly had the right to terminate an employee when it was obvious he couldn't come back to work in any sort of capacity for the foreseeable future. So when we ask how long is a leave, I know sometimes these questions, especially when leave is staggered, are complicated, but there is case law to say that leave does come to an end, especially when the interactive process has been robust, when it's been documented, when FMLA leave has been exhausted. So I'll just go back and give a shout out to the earlier slide on documentation and also to the leave management professionals who are really the front line of keeping those records. But there is a limit to the leave, and courts have come out and said that as recently as a couple months ago here in the Sixth Circuit.
You know, as a quick aside, a colleague of KM's and mine asked that we make this point because she just addressed this issue. On the point of leave management professionals, you want to be sure that only designated people are handling requests for leave and handling the FMLA documentation or other documentation. What you don't want to be is in a situation where one supervisor is saying, hey, sure, take 3 weeks, no problem, and then another supervisor is not. You want to be sure that these types of requests are being handled consistently and appropriately and in compliance with the law. So that's an aside, but something to bear in mind. But in any event, the Sixth Circuit case that Lauren just mentioned, kind of tees up and really addresses the next slide, which is, can an employee take additional ADA leave after FMLA leave? The answer is possibly. It depends on the circumstances. After it's exhausted, FMLA leave is sacrosanct, as Lauren mentioned. If they want to take leave, they get leave, period. After that leave is exhausted, that may continue. That leave is the only effective accommodation. However, unlike under the FMLA, the employer can, because of the interactive process, see or inquire as to whether there is an alternative accommodation that will allow the employee to come back to work. If it's effective and works as far as eliminating the barrier to performance of the job. Again, this will be fact specific, but you do have employers have a little more rights and leeway under the ADA when it comes to leave than they do under the FMLA. It is also a good idea, and the EEOC actually kind of addresses this point in its recent guidance on leave under the ADA. You may have form documents where you shoot it off to an employee on FMLA leave, and you say, okay, your FMLA leave exhausts X day, we expect to see you Y day, and that in case closed. You want to be sure that if there's a question as to whether the employee can return after the 12 weeks because you're on notice of it or you've received other information, it's important that you check in with their employees to see whether they may need additional accommodations in the form of leave. If the answer is yes, well then you can engage in the interactive process. But KM has the EEOC, as we point out here, what's the EEOC's position on sort of no-fault 6 months and done, 3 months and done policies?
Well, it's really about the application of the policy, right? And we're going back to our broken leg by broken leg, case-by-case analysis. This has to be an individualized look at a particular employee and what they need. But I think to your point, what's critical is after about 10 weeks or so of FMLA leave, you're on notice that there may be a disability under the ADA, and it may be worth it to have leave management reach out to the individual and talk about the return to work, so that it's not the Friday night before the Monday return where there's an email that comes through and can't be dealt with over the weekend.
Okay. Along the lines of the FMLA, the medical documentation supporting the need for a leave that we discussed earlier, the question becomes, can an employer require the employee to provide a fitness for duty or other medical documentation? Again, with the ADA, we're looking at the same standard. If you know the employee is fine and is able to come back to work under the ADA, it may not be job-related and necessary for you to request paperwork. But that said, you are allowed to if you need certification that the employee can come back to work. Importantly, you cannot ask an employee to return to work without accommodations, or you can't say no. You can't say to the employee, "You have to come back to work with no restrictions, or you can't come back." That is violative of the ADA's obligation that you provide reasonable accommodations to allow an employee to perform the essential functions of his or her job. So you just can't take the position, as much as you may want to, and we understand that it can be difficult. You can't insist on a restriction-free or accommodation-free return.
And I think some themes have continued to be repeated, and we'll repeat one of them here, which is documentation and consistency. Under the FMLA, what's clear is that if there's a policy for a fitness for duty certification, then it's got to be uniformly applied to any employee with an equivalent position. And here, under the FMLA, it's got to be compliant with the ADA. So the physical for the fitness for duty certification has to be job-related and consistent with business necessity. And we spent a lot of time on the documentation, the notice requirements, the certification requirements. They all add up. There was another Sixth Circuit decision over the last year where the Court of Appeals affirmed a district court and said that an employer interfered with an employee's FMLA rights, and it was all over a fitness for duty certification. They didn't inform the employee in the notices that a failure to provide a fitness for duty certification could result in denial of job restoration, and it certainly can, but without the proper notice and without the employee knowing that in advance of leave, the court said, yes, you're liable for FMLA interference. So fitness for duty certification is absolutely permissible as long as it's a uniform policy, but it's another one of these instances where the employee has to understand that that's part of the process before leave is taken.
In the ADA process, when someone is on an extended leave, and we'll talk a little bit about what happens when it keeps extending and extending, you will generally you'll have an idea of when the employee is able to come back to work, because you will have already received documentation from an employee's doctor indicating, Nora needs another 4 weeks. After the 4 weeks, she'll be able to return to work with no restrictions, or she'll be able to return to work, but she needs X modification, whatever it may say. So you may already have that. You may know that. So it may be again. You should never just assume that you can demand anything of an employee with a disability if you don't need it. And you don't want to. Furthermore, you don't want to treat disabled employees differently than you treat non-disabled employees, because that could cause different concerns under the ADA.
And now we come to reinstatement to a job after a leave is taken. So, Nora, what does the ADA say to us about an entitlement to reinstatement?
So the ADA language is a little different from the FMLA requirements. An employee is, under the ADA, an employee is entitled to return to their same job unless the employer can demonstrate that holding their position open will cause an undue hardship. So, that if someone's out on an extended leave of absence, they are assuming that they are coming back to their job unless you can demonstrate through documentation and otherwise that continuously holding it open for however many months or weeks are at issue is an undue hardship. And that is a significant burden to show. The EEOC regulations set forth numerous factors for what's an undue hardship and how that can be established. But it is important that that all these issues be documented. We've all had the situation where we've alluded to this earlier, someone is on an extended leave, you expect someone back on Monday, Friday afternoon you get the doctor's note saying, oh wait, we need one more week, or she needs more time, I'll be examining her in 2 weeks. And then that happens a second time, and a third time, and a fourth time, and the leave goes on and on and on. What's going to be important here, again, our consistent theme, is showing your documentation. You can't not reinstate someone because they continuously extended, but you can reinstate if they're not engaging in the interactive process. If you can document that you've tried to get more clarification on the need, on why the change, on when can this person return, when can we see that. This is where your documentation, your communications with your employee and or their doctors are going to become critical. It's hard to, again, these are all so fact specific, it's hard to come up with a hard and fast rule about how many extensions or what becomes an indefinite leave or what do we have to accommodate and not. But bear in mind that the interactive process and being able to show your communications where you're trying to engage the employee are going to become critical.
And so I'm going to keep going with our back injury, and we'll pick up where we left off with light duty. So workplace injury, a back injury, workers' compensation doctor says you're fit for light duty. The employee says no because that back injury is also a serious health condition under the FMLA, continues FMLA leave, and then exhausts it after the full 12 work weeks. And so upon that return, say the light duty position is available and the employee voluntarily accepts that, says, okay, I will take the light duty position as my doctor recommends. At that point, the employee no longer has a right under the FMLA to job restoration. So that's another key inflection point where we see overlap between these laws. But typically and generally speaking, the FMLA says, yes, you're entitled to the same or the equivalent job. What does equivalent mean? Here I think it's important to hone in on, pay, benefits, terms and conditions, but particularly pay and benefits. It's key to note that equivalent pay also includes any sort of unconditional bonus or payment. So if the employee would be entitled to it, if they were there and not on FMLA leave and it's an unconditional bonus, then you have to pay the bonus to the employee who is taking FMLA leave as well. So that's key. And I think the other thing to note here is that FMLA leave is not some sort of bubble, right? It's not a force field where you're protected from the day-to-day business operations. So if there is overtime that's been eliminated, or if an entire shift has been eliminated or restructured, just because an employee is out on FMLA leave doesn't mean that they're somehow insulated from the practical implications of the business.
Okay.
And I'll stop there, Nora, because I'm looking at the clock.
Yeah, maybe we've got time for one question, but just again, on the workers' comp piece, again, go by your state law. Often there's not going to be an automatic leave time or automatic right to reinstatement, but it's important that you be cognizant of your state law requirements and also cognizant of being able, that you cannot retaliate against or discriminate against someone for having exercised their rights. Do we have time for maybe one question, or?
We do have some questions waiting. We probably only have time for one or two questions, but if you do want to submit a question, you can do that by using the chat feature in the lower left-hand corner of your screen. And type your question in the available box and click on the Send Submit button. And if we don't have time now, maybe they can the speakers can get back to you.
Okay, we'll take the first question received, and that is, can I discipline an employee for failing to return FMLA or ADA medical certification?
KM, do you want to address that one, or would you like me to?
Sure. So if a certification comes back, let's say it's insufficient, it's incomplete, there's back and forth, and you're unable to get a complete certification that says the medical facts that are underlying this serious health condition. If that's the case and you've exhausted all of the options that we discussed today and an employee never produces a certification, then discipline's not appropriate, but a denial of FMLA protected leave is. So the leave that the employee would take there isn't FMLA protected, and that makes the overview slide that we went over at the beginning really key, because the leave doesn't receive those FMLA protections. Thinking of discipline, there was an 11th Circuit case I just looked at over the last week, and there an employee who was on a who was offered a light duty position said no and continued on a leave instead, and the company provided the employee with an additional 30 days of leave after FMLA leave, and his Facebook feed showed that he went to a theme park and took a nice trip to St. Martin and was clearly having a nice time, and one of his fellow employees shared that with management. And so upon the return from the leave, the employer suspended and then terminated that individual. And there it was because of a violation of the company's social media policy. But at the suspension and termination meeting, the company didn't reference those policies. And so we have to be really careful when we're taking decisions, suspension, termination. It's often that these employees have other issues going on, or sometimes health conditions can affect performance. So again, the documentation is key to play that broken record one more time, and to just really carefully document and assess risks along the way, especially when making a decision about termination that's proximate, that's really close in time to the exercise of any federally protected leave. Nora, I don't know what you have to add there.
No, I think that's right. I think it's not a matter of discipline. It becomes a matter of is the employee taking time off that isn't protected under the policies or under the law. And then if you've tried to get the documentation to document the time off, well then you can, and the employee has not provided documentation, well then you can proceed as though these absences are not protected or they're not excused. Depending on how your policy works, and you want to have equal enforcement and consistent enforcement of these policies as well.
And so we're running out of time here. We'll try and get back to those of you who've submitted other questions, but on behalf of Nora and me, thank you for navigating with us through the leave and disability landscape, and we'll close by saying that we'd like to leave you with our thanks. Please don't hesitate to call us with any particular questions or concerns.
Thank you.